so it's an issue where you will do a design for a client and then they take it and bid it out to a bunch of other people. And so, how is that my intellectual property, right?
I think maybe you could get them to sign a non-disclosure agreement and sue them on breach of contract. That's the only thing I can think of. You should do that.
Those are mean people.
Those are mean people.
It happens.
I never would have thought.
1 out of every 5 designs.
Wow.
I would have them sign a non-disclosure agreement before you even give them anything. Do you do bids for free? That's kind of how it works, or do you?
Yeah, it's, I mean, it ranges depending on how I kind of assess the client.
Yeah.
Generally, I'm gonna get paid for any design work. So in that case, you know, if they pay me well to do the design, well, they're free to do whatever they want with it. But if somehow I end up not charging them to do the design.
And then 2 months later you drive by and they've got your design on their front lawn. I would have them sign a non-disclosure agreement before you hand anything over.
Can you discuss what that is for?
It's, I mean, it's exactly what it sounds like it is. You, in exchange for you giving them information, they agree not to disclose it to anybody. So then they go out and they show it to other contractors, and then you take them to court for breach of contract. It's, that's another thing. That one shows up a lot in the patent world when inventors go out to try and pitch their inventions. We tell them to get non-disclosure agreements. So you can't sue them on copyright infringement or patent infringement, but you can sue them on breach of contract. So, yeah, that's probably my best suggestion. Question?
So, similar, is that why architects put on their drawings, like, you cannot, I don't know the exact wording of it, but similar to, like, you need our written permission to.
Yeah, sometimes architectural designs are eligible for copyright protection, so that would be the reason for that. But for something that's a little bit trickier, yeah, because even if you have a copyrighted work, you can still show it to somebody, right? So if you've got a book, you can show it to your friend. Look at, oh, I read this paragraph. So the copyright wouldn't protect you in the garden design, but I think a non-disclosure would. And if they don't want to sign it, just say, explain to them what's happened in the past, and most people sign it.
Yeah, no, there are also things you'll be involved in commercial projects where you're designing, you're engineering stuff. It's not even just a garden design.
Right.
So then what happens is like that specific thing that you engineered gets kind of like taken away and then like kind of taken by a different engineering firm or whatever, and then they just kind of like take your work.
Yeah.
So, you know, so there's a range of different kind of ways that it happens, and I always end up seemingly unprotected.
There's a broad array of sleaziness out there.
That's putting it lightly.
Well, I mean, I don't even think it's necessarily sleaziness. I mean, there's some of that,